Convicted double murderer Alex-Murdaugh get a new trial. That is up to the South Carolina Supreme Court. Hours ago, justices hearing arguments over whether Murdaugh deserves that new murder trial, focusing on evidence that was submitted in court of financial crimes and whether the now former clerk of court in Colleton County tainted the jury in any way. Our Kiki Gushu is in the courtroom and has a closer look at what happened.
I sat in the courtroom in the South Carolina Supreme Court and listened as Alex-Murdaugh's defense team argued to the 5 justices of South Carolina about why their client deserves a new trial. Now, 2 of those talking points surrounded around whether the former clerk of court in Colleton County, Becky Hill, influenced the verdict of any of the jurors. It also surrounded around the allowance of the financial crimes into the first trial. Take a listen to some of the main talking points today in the courtroom.
Parker versus Gladden, they only needed 10 or 12 to get a conviction. And the Oregon Supreme Court said, well, we had 10 that weren't influenced by whatever the bailiff said. The Supreme Court said very clearly, it doesn't matter, you're entitled to 12 impartial jurors.
That exchange Wednesday at the South Carolina Supreme Court, as justices asked questions of attorneys for Alex-Murdaugh and the prosecutors who want his conviction to stand. A key point, whether former Colleton County Clerk of Court Becky Hill affected at least one juror's decision-making. Under the Constitution, a defendant is entitled to 12 impartial jurors. The justices pressed attorneys on whether even one compromised juror is enough to overturn a verdict.
I mean, if only the people that may be innocent get a fair trial, then our Constitution isn't working.
Murdaugh's attorneys say Hill made comments to a juror that implied Murdaugh was guilty. The state said those comments weren't significant. Chief Justice John Kittredge signaled concern over how seemingly minor comments may add up.
We all can cherry pick some of these that are on the surface innocuous. Epic day, big day. And when viewed in isolation, they don't move the needle, arguably. But when those seemingly innocuous statements are considered in the aftermath of the originating statement, not to be confused and misled by the defense, those initial innocuous statements take on a very nefarious message.
Justice John Few was even more direct about Becky Hill's credibility.
If Becky Hill is not credible, it's not because she didn't see it, it's not because she doesn't remember it, it's because she's a liar.
The defense also said allowing extensive financial crimes evidence made the jury think he was a criminal before they had the evidence. Prosecutor Creighton Waters argued the financial crimes weren't just background noise, they were motive.
So what is relevant is not, well, it was just yesterday or it was last week or it was a year ago. What is relevant is what does he know all is about to come out? And that's a decade of him constantly staying one step ahead of the game through one theft as another. And that brings up the second point, that this is all interconnected. It's an unbroken chain, and you can't truly understand, in what is crucial, motive, you can't truly understand the boiling point if you don't understand the slow burn leading up to that.
Now we wait as the South Carolina Supreme Court justices deliberate and make their opinion about whether Alex-Murdaugh deserves a retrial. In Columbia, Kiki Gushu, News 19 WLTX.
On a windy and cloudy Wednesday morning, dozens of people arrived very early to the steps of the South Carolina Supreme Court to hear the hearing of Alex-Murdaugh. We're talking about prominent attorneys from across the Palmetto State, as well as a lot of pre-law students from colleges and universities here in South Carolina, and a bunch of fans who said that they wanted to be a part of history. Here's what they had to say about why they decided to show up so early.
A lot of ministers, they couldn't leave the church to go. And so I said, Lord, send me, I'll go.
Raymond Johnson is a preacher from Marion, South Carolina, who says he's never missed a day of the Murdaugh coverage.
I started from the beginning. You know, I felt so bad. I was laying down when that first happened, and the Spirit came in the room while I was laying down, and God touched my heart and told me to go.
He wasn't the only one who wanted to witness this hearing firsthand.
I think it's really important for even undergraduate students, especially at Clemson, to sit in on something so important.
That's why Clemson pre-law students Olivia and Morgan traveled from the upstate to be here.
My expectations going in as someone who wants to be a law student is just to learn more and just also see it firsthand, such an infamous case just for the state of South Carolina.
As the crowd of dozens filed into the courtroom outside the state Supreme Court turned from this to this.
Thank you. Be seated.
One notable attorney in attendance was Joe McCullough, who represents who the public knows as the egg juror that was mentioned during Wednesday's hearing.
If the egg juror's testimony was just as theoretically impeaching as Juror 70 or the alternate juror's testimony, 741, why wasn't the egg juror allowed to testify?
We spoke to McCullough following the hearing to get his reactions and what's next for him and his client.
I think she's about to be inundated with interview requests, but I think now she feels somewhat vindicated based on the questions at least. And ultimately, if there is a new trial grant, she may find herself being a witness.
McCullough also says this is far from over. We still do not have a decision from the South Carolina Supreme Court justices. McCullough also says this can possibly take weeks or even months. Reporting from the South Carolina Supreme Court, I'm Christy Calcagno for News 19 WLTX.
All right, we're being joined now by criminal defense attorneys Lori Murray and Brian Shealy to weigh in on what they saw today, to get their reaction to what happened at the South Carolina Supreme Court. Good evening to both of you. Lori, we'll begin with you. What are your thoughts right out of the gate?
I think that the writing is on the wall. I think everybody knows that. The writing is on the wall that he is absolutely going to get a new trial. They came out hard against Creighton. I was watching when Dick Harpootlian was giving his first argument, and I thought, well, they're just kind of throwing him some softball questions. And I thought maybe that would be the tone of the hearing itself, but it wasn't. Whenever Creighton stood up, the questions started coming, and the tones and the voices started getting a little bit louder. So definitely think I think that on all three counts and all three grounds for the appeal that they were going to find for Alex Murdaugh.
Brian?
Yeah, I mean, I was amazed at the kind of language they were using right out the gate. And I think I might have mentioned this before, but it's fairly rare that the trial advocates, the trial attorneys are then before the Supreme Court. Often that gets punted to an appellate lawyer and they're coming up with excuses, but here we have a really interesting opportunity for the Supreme Court to critique the combatants at trial, so to speak, for the state and defense about their strategy and why they did what they did. And so it comes to a lot of the arguments that the defense made, like the bad character evidence for certain. I was intrigued by that line of questioning by the Supremes about how think you can get this in. Well, it was a motive, and I got to tell my story, and they were like, yeah, it was hardly a motive. So, I mean, that kind of frank talk, is always kind of shocking to hear from the smartest people in the state, right?
Obviously, two things that were up for debate today, the admission of financial crimes in the original murder trial against Alex Murdaugh, and the questionable actions of former Colleton County Clerk of Court Becky Hill. And when it came to Becky Hill, we'll begin with that. The Chief Justice of the South Carolina Supreme Court basically said she went rogue. I heard him say something about going rogue. Her actions were improper. He even had Creighton Waters admit that what she did was improper today.
Yeah, and what she did was improper. And I think the biggest piece of evidence of that, Justice James talked about how they didn't let the egg juror testify at that hearing in front of Justice Toll, but they did let the alternate juror testify, and neither one of them, deliberated. So what was the difference between the two? I think that was a very important part that he brought up. And then just the sheer character evidence, Justice Few got very angry at one point and not only said, he didn't say she lied, he said she's a liar. And that was very strong verbiage, I think, coming from him. So, and all of that again was directed at Creighton. So it was a tough day. It was a tough day to be Becky Hill.
Becky Hill pleading guilty, as you may remember, to perjury, also misconduct in office late last year. But Brian maintained she did not tamper with this jury in any way.
course she maintains that. And I think at her plea, even, you know, the state and the judge, they were all, you know, discussing that this was not about, you know, jury tampering, and she was not charged with that. And, you know, that, my thought on that is, well, that's just selective prosecution. I mean, prosecutors have probable cause to bring certain charges all day long, and sometimes they won't do it for certain reasons. Maybe they don't think they can get it to a jury beyond a reasonable doubt, or other factors. So I think she's guilty of that all day long. It wasn't brought as a charge. She didn't have to plead to that. But I think it's clear that this court believed that she, you know, tampered with that jury. They got Creighton to stop playing with his words and admit that there was misconduct, that was improper. Yes, it was not just a fleeting conversation point. The words matter, especially from someone in a position of power that is in charge of that jury. And so, yeah, I thought it was very interesting that the chiefs or the justices were not playing around with, you know, let's let the air out of the room. She did wrong. Both sides agreed to it. She's a liar. So I think that was very interesting.
Are you guys surprised at how intense the questioning was here by the justices when it came to Becky Hill?
No, I wasn't. I mean, I thought that it should have been intense. And I wanted to go back to one point. I thought a very important part of this was when they said, you know, you can say that she didn't say these things that these jurors are coming up with, but we had an independent clerk of court from the upstate who said that Becky had said the same comments to her. So how would they have matched those up? And if that wasn't credible evidence, and Justice Toll heard from that clerk of court is a friend of Becky Hill's. So how you don't line those two up and find that the jurors who are saying that they heard Becky Hill talk to them, you know, influence their verdict, I think that Justice did a really good job of picking up on that and saying, look, this has been improper. They actually have. And whether, I thought they came at Justice Toll pretty hard too. You know, part of the thinking on all of this from the very beginning, when we talk about whether they would give a new trial, is whether they would be willing to overturn somebody like Judge Newman and somebody like Justice Toll. And today they showed that they were following the law.
And you mentioned Jean Toll. It kind of took a lot of people aback, I think some legal observers today, with what the state Supreme Court was talking about when it came to her and that decision that she made back in 2024.
Right. I mean, like Lori says, I mean, this case has had a lot of really excellent attorneys on both sides, but it's also, you know, the judges that were appointed were excellent. Judge Newman has a long history of excellence, and, you know, Chief Justice Toll was a trailblazer, and so she was kind of left with this mistrial motion with, you know, a certain amount of authority, but I do think she got it wrong. I think she misapplied the standard for jury tampering. I think not allowing the egg juror to, you know, that to come through, you know, that was not a good look. And, you know, at the end of the day, when you have such conduct like this, you have to kind of cast aside folks that maybe got it wrong and call them out for what happened, and just get it right on the law. Because, like I've said before, if our Supremes look the other way on such an extreme example of jury tampering and clear misconduct in this way, with a disgraced clerk who was financially benefiting from a guilty conviction, who has been investigated, charged, and pled guilty, and if we don't do something about this, even with Alex Murdaugh, who a lot of people think is the worst of the worst in the state for the crimes he committed, but if you set that aside and we allow an overlook for the kind of conduct that is designed to stay out of the jury room, the jury delivery room is a sacred place. If we let that go, then I have a big fear for our future jury system in this state. And so I think, like Lori said right out of the gate here, this is coming back all day long.
Mm-hmm.
It has to. If it doesn't come back, then I don't want to be a criminal defense lawyer practicing in front of juries in this state.
When you say come back, you mean a new trial?
Remanded for a new trial based on the Becky Hill issue alone, and very likely some other issues.
Well, let's talk about those other issues, because a lot of chatter today and tonight, excuse me, about Judge Clifton Newman allowing the financial crimes evidence into the murder trial. Seems the justices took issue with that as well.
Yeah, they did, and I think what we're going to see, because they had two issues. One, is this a plausible motive? Is it reasonable to believe that that is the motive? And then two, was there evidence above and beyond that was let in? And they talked about specifically the evidence of the victims coming in and people coming in and feeling sorry for the victims, and that's not motive. So even if they don't say this motive was improper, that it's not the motive, they don't go that far, because that will affect the trial down the road if they say this was not motive. But if they don't come in and say that, I think they're going to say, hey, yeah, we might could see that it was motive, but you definitely let too much of that in. You got into the victims, and that has nothing to do with anything other than he's a terrible person, and he is a terrible person. Mm-hmm. But they were right. They got that right.
Brian, Judge Newman, well respected among courtrooms, lawyers all across the state. Did it surprise you what you were hearing in the courtroom today from the justices when it came to this financial crimes evidence?
I was surprised when Judge Newman let it in, because his preliminary ruling was it wouldn't come in, and then he let it in when it was sought. So, it shocked me then. I thought it was a bad decision. I think that was well before any kind of allegations of misconduct and jury tampering by Becky Hill. So, before Becky Hill, that was going to be the major issue. I think it was severe enough to come back, have a case come back, because, it is a defendant waiving his right to remain silent and merely testifying in his defense does not open the door to any and all bad character evidence. It's too prejudicial. You can't get a clean trial on a murder case if over here someone's done terrible things and those get before the jury, because the line of questioning alone, do you trust this guy? Do you feel like you really knew Alex Murdaugh? To these financial crime victims, that was a theme for the state. And so I think they reached too far, the state did in this instance. I think they had a lot to go with on the murder case. I think Alex Murdaugh was probably willing to plead if allowed on the financial crimes and kind of set that aside. But the justices today were very incredulous as to that being a motive. I think one of them even gave an example like, that's not motive, Mr. Waters, for murder. That's a giant microscope on yourself by murdering your family to keep it away from your financial misdoings with your client's money. But, a better example of motive would be if there's a whistleblower and you killed the whistleblower to prevent blowing the whistle about the financial crimes. That is a more analogous motive. And they were pretty disparaging of Mr. Waters today about, it's any motive can possibly, and they're like, no, that's not how we do it. So it was pretty telling.
Attorneys for Murdaugh once again reminding the Supreme Court today there were no weapons recovered, not the murder weapons weren't recovered. There was no blood or DNA evidence tying Alex Murdaugh to the murders. Nothing in his home that we know of, nothing in his car, nothing on his clothing. Again, another reminder from the lawyers with the justices of the Supreme Court with this. Is that going to matter in the grand scheme of things when it comes to making some sort of decision here? Is it just simply going to be, did Becky Hill tamper with the jury? Is she not credible? Did the judge make an error in allowing these financial crimes?
I think it'll be important for the retrial, because if you get that motive knocked out and you get those financial crimes completely knocked out, then all you're left with is, hey, there's no evidence here. There's no DNA. There's none of the things that you said. We had that blue tarp somewhere, but what was that? I think that the state will have a much harder job if they come in and say that evidence, the evidence of motive, should not be allowed.
Let's talk for a moment about what happens next. It could be weeks, it could be months before the South Carolina Supreme Court makes a decision one way or the other. Is that right, Brian?
Yeah, I think this record is vast, and I think, the arguments were lengthy and thorough, so it could be months before there's a decision made easily, and I would expect it would take that long.
And what would happen, let's say, Lori, the South Carolina Supreme Court decides he gets a new trial. Would the state be able to appeal that to other courts? How far would it go?
That's a good question. I think it would just be remanded. If they're going to remand it down, they're going to remand it down and it'll go to a new trial. I don't think that there'll be any further appeal there.
And how do you get a fair trial now in South Carolina? This case has been all over the news for a long time now. A lot of publicity, a lot of information that is out there. How do you get a fair trial in South Carolina now if this goes back to trial, Brian?
You know, I was talking to one of the studio hands here about that very issue on a break because, I mean, that is the question. How do you get a fair trial in the biggest case maybe since O.J. Simpson or something? And the only answer I have for that is because you have a constitutional right to have the case tried where it all occurred. The only answer to it is that we have to, if it comes back, the defense would have to be allowed, and the state as well, to get enhanced jury voir dire. You know, in capital cases, death penalty cases, you get that. You get attorney-conducted voir dire where you can ask a lot of questions more than just your standard judicial-conducted voir dire. You know, who'd you vote for, what bumper stickers on the back of your car kind of thing. But for this, I think you'd have to have that. It's normally not permissible on a normal case unless it is a capital case, but I think that's the only way you get a fair and impartial jury, because otherwise, if you're trying to get someone that has no idea what happened in the Murdaugh trial, and if you find that person, they're probably not fit to serve. They're in a bunker someplace, or they're not.
Or they just turned 18.
Or correct. So like, I think it'll take that. I think it'll take enhanced jury voir dire, and that could help both sides weed out impartial people.
Intense media coverage with this, and again, Lori, your take on getting a new trial, because you'd have to be living under a rock or completely disconnected not to have heard anything about this case.
Well, I think Brian's absolutely right. They have to do some intense voir dire questioning of the jury and looking into the jury panel before they even get there. There's no way that nobody's going to have heard of this case. So what you have to do then is weed into, can you be impartial even though you've heard of it? You want to make sure you don't get those people that are looking to get on the jury because they believe he's guilty and they want to be the one to put him away. You got to make sure that those people at least have the ability to look at the evidence and be fair. All
right, a couple of questions left. I want both of you to answer this. Your gut feeling here, what do you think is going to happen with the South Carolina Supreme Court, Brian?
Coming back.
New trial.
I think it's going to come back for a new trial on the jury tampering issue alone. And then, you know, they don't have, if they come back strong on that, they don't necessarily have to go into every other issue. They may decide to put a marker on this so that the next trial is conducted a little bit differently. That's totally up to the justices. But I think it's going to be remanded for a new trial.
Lori?
Absolutely. No question about it. I think that within the first 5, you know, they gave Creighton Waters 5 minutes to speak without being interrupted. I think within the next 5 minutes, we knew that it was coming back.
And that's another thing, the length of arguments here. We were initially told it would be 30, 30, and a 10-minute rebuttal. Then we were told it would be 20 minutes for each appeal, so basically 40 minutes. But these attorneys would a lot longer. This should have been wrapped up in about an hour and 45 minutes. Instead, we pushed 3 hours for this appeal hearing today. Is that normal with appeals?
Nothing's normal about this case. As long as the justices still have questions and they're allowing you to speak, then you can speak. If they were strictly adhering to the 20-minute, 40-minute rule, then you got to be quiet. But they were continuing to ask questions, getting responses, and asking more questions. So,
I was going to say, I did laugh because I think Jim Griffin tried to sit down. But in the middle, they were like, wait a minute, we have another question.
He did after... You're right, Lori. He did after answering one question very well. He said, all right, guys, thank you. And they said, well, wait a second.
Do you want to end on that one? He was like,
He was ready to sit down already.
Very inquisitive South Carolina Supreme Court. And that leads me to the fascination with this case. I guess attorneys have a fascination with it. Obviously, the state Supreme Court trying to make a decision in this case. But the public fascination here continues all these years later. Why is that?
I mean, this case had everything to it. You got Southern... you know, well-to-do family that lives on the country plantation. It's almost, you know, picture perfect, or would it seem on the outside, but then on the inside you have all this, you know, this financial crimes and this boating death. And so the combination of all of that is what made this case so interesting from the very start. And then you're going to add in now the jury tampering and these financial crimes and all of the stuff that came behind the financial crimes. It is honestly, I hate to say gift that keeps on giving, but there's just something to it every day. The legal issues alone. Do you know how much the public has learned about the law from this case? I mean, it's crazy.
Yeah.
So yeah, I mean, it keeps on giving because this is something that doesn't happen to this type of family, I think is what people say.
Got it. And Brian, just to clarify for our viewers at home, even if Alex Murdaugh gets a new trial right now, he's not getting out of prison because he's serving, 40 years for stealing $12 million, is that right?
Right. I mean, he's going to die in prison. And I think this is more about clearing, the murders of his family. I mean, he's going to be paying for the financial crimes for the rest of his life, but this is purely about his legacy. I believe this is about his attorneys trying to set that straight. And we could talk about, everything else about his connection to the actual killings and whether we think he did or not. But I think this appeal is purely about his legacy and what he thinks is right.
I think we also it's important to note too that if the murder goes away, he will be serving his time in federal court and not in state court, which is a much nicer place to be.
All right. Final question. How long do you think it's going to be before we hear something from the South Carolina Supreme Court?
I think they had their minds pretty made up when they went in there. So I don't think it will be months. I think it'll be, maybe a month, but I think that they knew what they were doing when they walked in the door.
Yeah.
But
they got I don't think the order is written yet.
No, I don't think it's written.
And I think they're going to have to take their time with it. And there may be some more time added than they need, maybe for propriety's sake.
Yeah.
I think I might have said earlier that 3 months would be my marker. I'm feeling a little bit, now that I talk to more people, maybe it's closer to 2.5, but I don't think it will be weeks. But we can bet on that.
No, I'm not taking that bet. No way.
All right. Criminal defense attorneys Brian Shealy, Lori Murray, thank you so very much for your time. As always, we have much more on this on our website. Simply go to WLTX.com.